provides an introduction to the law section of the course. It will cover some basic terms and terminologies that we'll use over the next few weeks. So the legal system in Canada is actually based on the British legal system, English common law. In English common law, laws can come from legislation, which is what the government writes, or legal precedents, where judges rule on cases before them, and the precedents that those cases then set can be used in future cases. To go through some basic terminology, litigation is basically a term that refers to a lawsuit. When a case is brought before the court, the person who is bringing the case, who has a claim or a complaint, is called the plaintiff. The person who is being complained against, or against whom a claim is being made, is called the defendant. If a case has been decided by one level of court, it can go to a higher court to appeal the decision made by the lower court. The group who is choosing to try to appeal is called the appellant, and the group who is trying to uphold the decision made by the lower court is called the respondent. Whenever there's a legal relationship between parties in a contract, that's referred to as privity of contract. It's not specifically relating to how private the contract is, it's just the parties involved. For the law questions in the professional practice exam and in your final exam, there are two types of questions. There is typically one question looking at definitions of standard legal terms, and then there are a number of questions looking at case studies where you're expected to determine the aspect of engineering law that applies to them. The types of law that could be raised are so-called tort law, which we'll talk about later on today briefly, contract law around getting a contract, whether the contract is legal, what happens when a contract is being executed. Equity in terms of human rights and employment equity, environmental laws, and then other laws around controlled goods or security or privacy. The next few slides go through some high-level concepts which we will revisit in subsequent office mixes. To have a contract between parties, there have to be 5 elements present. An offer of goods or services has to be made and accepted. There has to be intent of both parties to actually enter into a contract. There has to be some form of consideration, so there has to be some benefit or negative impact to both parties. There has to be a capacity to contract, so for example, children are often not in a capacity to build a legal contract, although there are places where they can. And you can only have a contract that does something legal. A contract can be made in a written form or an oral form. So for example, when you go to Tim Hortons and buy a coffee, the offer is made through the prices advertised, it's accepted by your asking for a coffee based on that. There is a mutual intent there to provide a coffee and buy one. You provide money in exchange for the coffee that you're given. You have the capacity to buy a coffee, and coffee is perfectly legal to sell and buy. With regard to so-called tort law, this covers a case where the person who is being claimed against owed the person who had a claim a duty of care. They should have protected the plaintiff in some way, and they breached that duty of care by what they did. And as a result, the defendant had some injury. That could be financial injury as well as personal injury. And so duty of care consists of ensuring that a reasonable person would accept that the actions were reasonable by the defendant. For professional engineers, the standard for duty of care can be much higher than for a layperson. If the injury that was caused was not foreseeable, that might be a reason why that duty of care was not confirmed. In cases of tort law, there's no requirement to have a contract between the defendant and the plaintiff. So if I am building a bridge and you're driving under it and a brick falls on your head from my building a bridge, even though there is no relationship between me as a bridge builder and you as a member of the general public walking under that bridge, you can pursue me under tort law. Once a tort has been established, a wrongdoing has been established, then we can talk about the responsibility for providing compensation to the plaintiff. So we talk about liability. There are two types of liability that we talk about. Strict liability applies to any manufacturer for damage resulting from something that they've made, even if their production of it was not negligent. So basically, companies take out liability insurance to allow people to claim against them for harming themselves with a product, even though, as a manufacturer, you did everything you could to avoid that harm. In Canada and elsewhere, we talk about a term called vicarious liability. So if an employer commits some tort against a person, a third party, then the employer will have so-called vicarious liability for whatever the employee did, because they are expected to have much more money than the employee. In other words, employers are expected to make sure their employees aren't doing crazy things. If there are multiple people involved in tort, multiple wrongdoers, those are called concurrent tortfeasors. So just to end with, when you're addressing one of the law case studies, again, it's useful to have a structure similar to an ethics question. And so when building a law question structure, it's worth introducing the case, defining the legal concept that the case is dealing with, and going through the brief history of that legal concept, including what the key cases were that defined that legal concept. You should then analyze the particular case you're dealing with, who was responsible, who were each of the parties, have the conditions for the legal concept been shown to be true, what liabilities would exist under that legal concept, and then finally provide a decision. So state what you believe a court would decide and what damages would be recoverable from whom, assuming the decision is for the plaintiff. And so you need to make clear connections between the case in question and the legal concepts that we discuss in class.